fun things about my industry career is I had the opportunity as an inventor to have some of my inventions patented. One of the not so fun things about my industry career is I got the opportunity to defend my company when it was accused of patent infringement. By the way, we won that case in a very clear way. We did not infringe anybody's intellectual property. But I've got, through those experiences, I got the chance to see how intellectual property is made and how it's defended pretty up close and personal. And so when I offer this following observation as a quote from myself, intellectual property rules are weird, I kind of know what I'm talking about. What I mean by that is your expectations of how it ought to work are probably wrong. Now, I was a little bit gratified as I got to know my good friend David Henry, one of the premier intellectual property patent attorneys here in the Central Texas, and when he tells me that after years and years of practice, the experience of many of his clients is parallel to that. The common mistakes are made all the time, even by major companies who invest in intellectual property routinely, hire very experienced counsel. There are nuances to how intellectual property law is going to work and how the courts who judge what's right and wrong work, and it's critical that you know what you're doing because many corporations lose a lot of money because they get it wrong. So this is an area where you have to pay attention. It's an area where you shouldn't do it yourself, and you may not always get what you pay for, but you rarely get something you don't pay for. So be willing to invest in good counsel. To see what your current state of knowledge is about intellectual property, and there are three forms we're going to talk about: copyrights, trademarks, and patents. I'm going to give you a short test on some facts about intellectual property. On each page, your job is to figure out which ones are actually true. So the first category is copyrights. Fact number one: if you change someone else's work enough, something around the % change rule, you can get around a copyright. Fact number two: if you pay for a copyrighted article, an item, you own it, especially if you paid to have it made. It's called work for hire. And if you only, and the other fact that I want you to evaluate is whether or not this is true. When you, you only have copyright protection if you file something with the government. Have you figured out which ones are true? Well, while you're making your notes, we're going to go to the next page of the test, which is about trademarks. Fact number one: the trademark system exists primarily just to make companies rich. Fact number two: if the Secretary of State's office says that a name is available as a corporate name, then you're free to go ahead and put it up on signs, do business under that name, brand your products under that name, and so on. Fact three: trademark infringement is easy to understand and to avoid, because all you have to really do is differentiate spellings a little, change capitalization, just make it look a little different. Have you figured out which of these facts about trademarks is true? Maybe the trickiest one of all is patents. So I've got 4 facts for you to look at on patents. The first one's a really handy fact. It's called a poor man's patent sometimes. That you can protect an invention by simply mailing yourself a copy of it, get a postmark, and inside that envelope have the description of your invention. Second fact is that you cannot patent something if it's simply a new combination of old parts. The third supposed fact is if I get a patent on my invention, then of course that means I can make it. And lastly, people use this fact often to decide not to invest in patents because they are expensive to get, but it's because it's going to be easy to get around. Maybe somebody could get around yours easily. All they're going to have to do is change a couple things about that item and they can get around your patent. Sometimes, I said, that's used as a discouragement from going through the process of getting coverage. Okay, so for all you inventors in the room, which of these is true? Turns out, absolutely none of them are true. So, way differently, way different outcome than failing a test in school. What this means is you're probably going to kill your business if you don't figure out how to manage IP. Beyond having a business that dies and somebody else takes advantage of, I want to give you one more very solid reason, courtesy of my friend David Henry, about why you should care about IP. This data is taken from a study that looks at the stock market value of companies on the S&P 500 and attributes the percentage of that is tangible and how much of it comes from the intellectual property side, the intangible side of their business. As you can read, it's a rising number, and it's now over 80% of the value of the S&P, nearly 90, has to do with intellectual property. That means if you don't get this right, you can destroy that fraction of your business. So here's what you need to learn. I realize I haven't told you how to do intellectual property. I haven't told you how to create brands. I haven't told you how to get patents. It's not my job to do that. I'm not qualified. I'm not an intellectual property attorney. The main takeaways I want you to understand is that you have to get this right and you need good help. You cannot afford to underinvest in intellectual property in any of its forms. So you're going to turn to a lawyer. Let me give you some advice. Most lawyers have no understanding of intellectual property. Most of them don't practice intellectual property. But among firms that do practice intellectual property, you will find a great variation in the level of quality of their work. And the best way to know in the area of patents, for example, how good your attorney or your group of attorneys is in writing patents is look at the record that the patents they write have in court when when people have been sued over them. If they don't stand up in court, they're not worth anything, because you know what? There's no sheriff in town for intellectual property except the court system. So the only way to know you have a patent that's worth having is if it stands up to a test in court. So my rule of thumb is find out who's really good at litigating IP and use that firm to create IP. You won't go wrong that way. It won't be the cheapest approach you can come up with, but it will be the most sound. Which brings up the third issue, which is how am I going to afford really good counsel? Well, you might be surprised how not so greedy many lawyers really are. I know they have a bad reputation. I have found some, even in a business that I'm helping to start, was offered by one of the top firms in Dallas, Texas, offer of doing all our legal work on intellectual property and corporate law for a share of the business. That's a great way to do it. If your story, your connection to the customer, and your strategy is so inspiring that the law firm is going to put their best people on it and get paid when you win, then you've got a good story. Well, if you don't, then at least go out and raise enough money to do this right. It's not worth the anguish and energy it's going to take to succeed in the marketplace only to give it away. So when you find an attorney that you can talk to, there's three questions you need to be asking. What can I patent? What can I protect as a trade secret? And how will I protect my brand? Those are fundamental to pretty much any of the businesses you're going to start, and you need to be thinking about those and need to get good help as you do. When we come back next time, we're going to pull all that together, and that intellectual property summary will probably change what you thought your strategy needed to be. Be prepared for that, but we'll pull it all together, crystallize it into a strategic plan you're ready to act on.